Okay, class, I'm going to be dictating your tests, and so they're jury charge. And let me just give you a stroke. And it was the word on your speed building, ignominious. And it's I-G-N longo, M-I-N-Y-O-U-S. So let me write it down, okay, from your speed building. I-G-N longo, M-I-N-Y-O-U-S. Okay, so there's that word that came out. And thank you to Suzette that texted me how to write it. Okay, and so here we have your test, you all. And so you've got on your 140 jury charge test number 1, the court, capitalized court, when you can replace judge in the sentence. And remember, you write the court Dort. Okay, this is 140 jury charge number 1 for 5 minutes test. Members of the jury, now that you have heard the evidence and the arguments, the time has come to instruct you as to the law governing this case. Although you as jurors are the sole judges of the facts, you are duty-bound to follow the law as stated in the instructions of the court and to apply the law so given to the facts as you find them from the evidence before you. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your sworn duty to base a verdict upon any other view of the law than that given in the instructions of the court. You have been chosen and sworn as jurors in this case to try the issues of fact presented by the allegations of the indictment and the denial made by the not guilty plea of the defendant. You are to perform this duty without bias or prejudice as to any party. The law does not permit jurors to be governed by sympathy, prejudice, or public opinion. The accused and the public expect that you will carefully and impartially consider all the evidence, follow the law as stated by the court, and reach a just verdict regardless of the consequences. The law presumes a defendant to be innocent of a crime. So a defendant, although accused, begins the trial with a clean slate with no evidence against him. And the law permits nothing but legal evidence presented before the jury to be considered in support of any charge against the accused. So the presumption of innocence alone is sufficient to acquit a defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt from all the evidence in the case. The indictment or formal charge against a defendant is not evidence of guilt. Indeed, the defendant is presumed by the law to be innocent. The law does not require a defendant to prove his innocence or produce any evidence at all, and no inference whatever may be drawn from the election of a defendant not to testify. The government has the burden of proving him guilty beyond a reasonable doubt, and if it fails to do so, you must acquit him. Thus, while the government's burden of proof is a strict or heavy burden, it is not necessary that the defendant's guilt be proved beyond all possible doubt. It is only required that the government's proof exclude any reasonable doubt concerning the defendant's guilt. A reasonable doubt is a real doubt based upon reason and common sense after careful and impartial consideration of all the evidence in the case. Proof beyond a reasonable doubt, therefore, is proof of such a convincing character that you would be willing to rely and act upon it without hesitation in the most important of your own affairs. If you are convinced that the accused has been proved guilty beyond a reasonable doubt, say so. If you are not convinced, say so. Any evidence as to which an objection was sustained by the court or any evidence ordered stricken by the court must be entirely disregarded. The jury will remember that a defendant is never to be convicted on mere suspicion or conjecture. A defendant may be proven guilty by either direct or circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. It requires only that the jury, after weighing all the evidence, must be convinced of the guilt of the defendant beyond a reasonable doubt before he can be convicted. While you should consider only the evidence in the case, you are permitted to draw such reasonable inferences from the testimony and, okay, and we'll get ready for your second 140 jury charge. Proper names, you have Fort Worth Division of the Northern District of Texas, Philip M. Ballard, Internal Revenue Service, Department of the Treasury, Title 26, United States Code, Mercedes-Benz. And so you have Internal Revenue Service. I believe there's a brief. There it is. Add the S. So it's SPWEFRBS. And this is 140 number 2 for 5 minutes. In other words, you may make deductions and reach conclusions which reason and common sense lead you to draw from the facts which have been established by the testimony and evidence in the case. You as jurors are the sole judges of the credibility of the witnesses and the weight their testimony deserves. You should carefully scrutinize the testimony given, the circumstances under which each witness has testified, and every matter in evidence which tends to indicate whether the witness is worthy of belief. Consider each witness's intelligence, motive, and state of mind and demeanor and manner while on the stand. Consider the witness's ability to observe the matters as to which he has testified and whether he impresses you as having an accurate recollection of these matters. Consider also any relation each witness may bear to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause the jury to discredit such testimony. Two or more persons witnessing an incident or a transaction may see or hear it differently, and innocent misrecollections like failure of recollection is not an uncommon experience. In weighing the effect of a discrepancy, consider whether it pertains to a matter of importance or an unimportant detail, and whether the discrepancy results from innocent error or willful falsehood. If you find the presumption of truthfulness to be outweighed as to any witness, you will give the testimony of that witness such credibility, if any, as you may think it deserves. If it is peculiarly within the power of either the prosecution or the defense to produce a witness who could give material testimony on an issue in the case, failure to call that witness may give rise to an inference that his testimony would be unfavorable to that party. However, no such conclusion should be drawn by you with regard to a witness who is equally available to both parties, or where the witness's testimony would be merely cumulative. In the final analysis, it is the responsibility of the jury to make its own independent decision as to the ultimate facts in this case, and to reach that opinion based on all of the evidence regardless of the source from which it came. the burden is always on the prosecution to prove beyond a reasonable doubt every essential element of the crime charged. The law never imposes upon a defendant in a criminal case the burden or duty of calling any witnesses or producing any evidence. The indictment reads as follows. On or about July 2, 1986, in the Fort Worth Division of the Northern District of Texas, Philip M. Ballard, defendant, did knowingly and forcibly rescue and cause to be rescued property lawfully seized by the Internal Revenue Service, Department of the Treasury under Title 26 United States Code, to wit, one black 1981 Mercedes-Benz motor vehicle, Texas license number YBQ231 and vehicle identification number WDBC B20AX BB003179 in violation of Section 7212B Internal Revenue Code, Title 26 United States Code, Section 7212B. The Section 7212B of the Internal Revenue Code reads in part as follows. B. Forcible rescue of seized property. Any person who forcibly rescues or causes to be rescued any property after it shall have been seized under this title or shall attempt or endeavor so to do shall be guilty of an offense against the United States. The elements of the offense charged in the indictment are as follows. 1. The seizure of property by one authorized to do so under the Internal Revenue Code. 2. Knowledge by the defendant that the property has been so seized. And 3. A forcible retaking of the property by the defendant. Lawfulness of a seizure under Section 7212B means only that it, and pecuniary was the word. Sorry, you all. That was a little tough. And we'll get ready for your 120s. Peculiarly. Okay. Let me see if that came out. That was the word. Peculiarly. So it's Peculiarly. Okay. And we'll get ready for your 120s. So you have on your 120 jury charge number 1, proper names. You have Mary Clark, David Clark, Commissioner of Internal Revenue. So remember, Internal Revenue was just SPWE. Okay, SPWEFRB. 120, number 1 for 5 minutes jury charge. If you believe that the reasons stated by the plaintiff, Mary Clark, and by the plaintiff, David Clark, as the motives for their refusal to deduct and withhold taxes on the wages of their workers were given in good faith and based upon their real beliefs, you must decide that their failure to so deduct and withhold was not willful, as that word is used in the penalty statute. The word willfully used in the statute on which this penalty assessment was founded means more than knowledge and intent. It denotes an act which is more than intentional or knowingly or willfully done and means an act done with a bad purpose or a wrong motive. The plaintiff's refusal to deduct and withhold was intentional and was without legal excuse. Yet, nevertheless, it is for you to decide now whether or not it was prompted by that bad faith or evil intent, which the statute makes a part of the offense. The mere knowing and purposeful default in the collection of this tax by deducting and withholding where there has been no failure to disclose the debt is not meant to constitute an offense of any degree. Willfulness in such a case as this must include some element of evil motive or want of reason. By way of example, and not by way of limitation, willfulness may be inferred from acts such as keeping a double set of books, making false entries or changes or false bills or documents, burning of books or records, hiding of assets or hiding of sources of income, handling of one's affairs to avoid making the usual records, and any conduct the likely effect of which would be to mislead or to hide. The plaintiffs, in order to be subject to the penalty brought against them by the Commissioner of Internal Revenue, must have willfully failed to deduct and withhold the tax from the wages of their employees, and the doing or omitting to do a thing willfully implies not only a knowledge of the thing, but a determination with a bad intent to do it or to omit doing it. The word willfully, in the ordinary sense in which it is used in statutes of this kind, means not merely voluntarily, but with a bad purpose, and is understood as showing an evil intent without an excuse. The object of the law and all its stringent provisions is to prevent fraud upon the revenue and to secure the tax levied. You must find for the plaintiffs, unless you find that fraud upon the revenue was intended by them, or unless you find that they had a motive to evade the tax. If you determine that the plaintiff's dominating motive was to find whether or not the rules of law requiring employers to deduct and withhold this tax from the wages of their employees were constitutional and legal, your verdict must be for them, since such a motive is not an evil one or one without reason. Willfully means knowingly and with a bad heart and a malicious intent. It means having a purpose to cheat or defraud or to execute a wrong in connection with a tax matter. It is not enough if all that is shown is that these plaintiffs were mean or stupid, careless, negligent, or grossly negligent. A person is not willful if he is careless about keeping his books. A person is not willful if all that is demonstrated is that he made miscalculations of law. He is not willful if all that is shown is that he, in good, and then you have your second 120. James Carl Young, State of Georgia. Okay, so state of, we've got STAOF with an asterisk. Okay, Georgia, GA twice with an asterisk. And let me write them for you. State of, STAOF asterisk, Georgia, GA twice with an asterisk, okay? Here we go. 120, number 2 for 5 minutes. Ladies and gentlemen of the jury, You have now been formally chosen as the members of the jury in this case, and I will now instruct you that the defendant before you, James Carl Young, must be considered by you to be innocent of all the charges brought against him by the indictment here presented. This is not a choice that you as jurors have. It is necessary that you hold this assumption in your minds until you find beyond a reasonable doubt that he is guilty of the crime or crimes charged. The presumption of innocence must remain with the defendant through the scope of this trial unless and until the evidence proves to your total belief that he is indeed guilty of the crime or crimes charged beyond a reasonable doubt. This is a trial that is literally a matter of life and death. For that reason, I would ask that we have your full and undivided attention during the entire trial. The defendant, James Carl Young, is charged with 2 counts of first-degree murder. Now, because the burden of proof is on the state of Georgia to prove the guilt of this defendant beyond a reasonable doubt, let me define that term for you, because it is a vital part of these instructions, and you should be clear about the meaning of the term. A reasonable doubt is such a doubt as would fairly and naturally arise in your minds, and by reason of which you cannot say that you have a firm conviction of the guilt of the defendant. Now, once you have heard all of the evidence that is presented here and have viewed all of the exhibits that are presented, you find that your mind is not clearly convinced that the defendant is guilty. If you are wavering or doubtful in any way, you must acquit the defendant. A reasonable doubt must be such a doubt as would cause a prudent man or woman to pause or to hesitate before acting in matters of importance in the everyday affairs of life. Now, the reasonable doubt may possibly arise from evidence, or it may arise from a lack of evidence in the case. You must not search for doubt. You must not make up in your own mind a doubt that is not based on reason and common sense. If you have a total and abiding conviction of the guilt of the defendant, then you are satisfied beyond a reasonable doubt. If not, you are not convinced past a reasonable doubt. As you serve on this jury, you are the judges of the weight of the evidence given here, the veracity of the witnesses who take the stand, and the conclusions to be made from the facts and inferences that have been proved here. It is your job as jurors to reconcile testimony that is conflicting if you can do so. If you cannot do so, it will be your job to give credit to that testimony and to those witnesses who you find are most worthy of belief. Ladies and gentlemen, and if you're not giving strict heed to my words, please do. As you make your decision as to the truthfulness of the witnesses, you should address their appearance, their age, their demeanor as they testify, their conduct, their intellect, the strength of their memory, their knowledge about the things of which they speak, the interest they may have in the outcome of the trial, and the truthfulness or untruthfulness of their testimony. And you may consider in reaching your verdict whether the, and that concludes your 120s. That one was a good one, you all. Have a great day and good luck and type them up, okay? Type up your tests.